Hi, everyone. It's Hunter Lott, your HR problem solver on demand. And this is take 5 from our series, Please Sue Me. I've been talking about several of these cases and things that are potentially bubbling up in employment law. So I thought it was time to summarize. So in this episode, a little summary on employment law and kind of where we are. First, the old exempt and non-exempt. You've heard my rants that we've got to get our act together on pay and overtime. This one is to adjust the salary threshold. Remember, just because you put someone on salary doesn't make them exempt from overtime. It's a combination of salary and job duties. And there's a minimum threshold. Right now, it's 35,568. Proposal is to raise that. Various administrations dating back to Obama have tried this with limited success. So we'll see kind of where this proposal goes. And if it's tied to inflation in our current situation, it could go up in a hurry. This ruling was already made, NLRB, on non-disparagement in various severance and agreements. And the general counsel for NLRB says, we really don't like these at all in any agreement, any form, and we're going to go back, retroactive. Wow. I can't imagine that there won't be a challenge to this. I certainly don't want to be the test case. We'll see. We'll see where this one goes. This proposal deals with no competes and eliminating them as a restraint of trade, Federal Trade Commission. Interesting. About 12 states, you may have seen my Take 5 unrestricted covenants. 12 states have already limited in some way. 3 states, Oklahoma, California, I think North Dakota eliminated them. And so there are ways to deal with this. And we talked about it in another Take 5. Make sure your non-disclosure is well done. It'll cover property, intellectual property, and trade secrets, and then non-solicitation of customers. So review with local legal counsel to make sure these are protecting you. While you're talking to the attorney, ask about arbitration. For a long time, arbitration was out, then it was in. The court's gone back and forth on this. I have various clients, subscribers who have a separate arbitration agreement. So this is something to run by your legal counsel. This particular case was the Ninth Circuit. California said you can't ban mandatory arbitration employment, blocks the California ban on it. So we'll see where that goes. This article in The Economist says that pay transparency is not working. And whether it's working or not, I think it's coming. Shining the light of day on this, being able to post minimum maximums for a job, communicate that, very transparent with that. Colorado, California have already gone to this. I think this is coming. This forces us to get our act together on compensation ranges and pay. Pregnant women, this shouldn't be hard. Can we accommodate them at work? Of course we can. This kind of codifies and expands some of the laws, the Pump Act, on how to deal with women and pregnancy and newborns and breastfeeding and the like. So make sure you're in compliance. A couple of Supreme Court cases. One is affirmative action. They've kind of chipped away at this over the decades. Is this finally when we say at the education level that something will be done? Won't affect. I don't think the Supreme Court can surprise us. That'll affect a lot of us outside of the education realm. This one, however, this one's interesting. This is a postal worker saying, "Hey, I want my Sabbath." You say, well, the post office doesn't work on Sundays. Well, they got an agreement with Amazon, and so now they're delivering boxes on Sundays. So they've heard oral arguments on this. It'll be interesting to see what this court says about Sabbath, definition of Sabbath, and what this could mean in our workplace. Check out all our resources at hunterlot.com. Thanks for watching. We'll see you next time on Take 5.